May it please the court, Madam Chief Justice. My name is Charles Herman, and I represent Mr. Jeffery P. Northway, the appellant in this case. This case is about the reasons why and the procedures by which a duly elected public official may be removed from office pursuant to Section 45 of the city charter provision of the city of Springfield. Mr. Northway took office in November of 2009 as mayor of the city of Springfield, a town of about 1,200 people. He was elected in November 2009 and took office in January 2010. A mere 10 months after taking office, the appellees filed ethics charges under the City of Springfield Ethics Code Ordinance on October 13th, 2010, which the Ethics Committee of the City of Springfield ultimately decided had no merit. On November 22nd, 2010, the appellees, City Council members asked for Mr. Northway's resignation pursuant to Section 45 of the Charter. And on November 29, 2010, the appellees filed a rule in the Superior Court of Effingham County seeking Mr. Northway's removal from the office of mayor pursuant to the same charter provision. We're here today. Following that, they had a bench trial July 6th, 7th, and 8th, and the Superior Court issued an order removing Mr. Northway from office on August 1st, 2011. 7 months after.
During your discussion of the proceedings along the way, at some point, will you try to also address the two motions to dismiss that were filed, and if or why no appeals were filed from those motions?
Yes, Your Honor. We filed a motion to dismiss based off of the unconstitutional due process violation on its face that Section 45 of the city charter did not provide the rudiments of due process consistent with Ludowici versus Stapleton, and also that the Section 45 of the city charter was vague and overbroad, and that it violated due process in the First Amendment. And the judge issued an order. We asked for immediate review and were denied that at that time. He indicated that he wanted all the issues that were going to be appealed at the same time. Following the motion to dismiss based off of res judicata and collateral estoppel was decided in June 29th, I believe, is when the order was issued, and and that was the same day the pretrial order was made, and then the trial was held almost a week later. So no, we didn't try to appeal that directly. That takes me to my first point, which is that Section 45 cannot be interpreted in a way that comports with due process, and here's why. The City Council, according to the city charter provision, is required to make a finding of guilt, make a judgment that the mayor, the member of City Council, is guilty of one of the listed grounds for removal under the charter provision. And in that event, and only in that event, are they authorized to bring the rule in the Superior Court. In this case, there was no notice of the charges against Mr. Northway at the time where the City Council made its judgment of guilt, and there was also no opportunity to be heard. There was no standard of proof delineated in the city charter provision by which Mr. Northway could have been protected against an erroneous decision by the City Council members. And also there was no rights to mount a defense. He couldn't call witnesses or cross-examine the witnesses of the City Council members at the time that they asked him to resign. In addition to Ludowici versus Stapleton, which clearly says that notice and opportunity to be heard should be had prior to an impeachment, which is basically what happened here, even though it's called something else. They filed a rule in Superior Court setting forth the charges as required by Section 45 of the city charter, and that would be similar to an articles of impeachment. And also in Ludowici, Eves versus Harris is mentioned, and in Eves versus Harris, 45 OCGA 45.5-6 was implicated, and in that situation, they argued that prior to the commission making a determination of whether or not the public official who had been indicted on felony charges should be suspended, that a hearing at that stage when the commission made that determination was not required because a grand jury had already made a finding of probable cause based on the charges, and so the hearing wasn't required. But Eves versus Harris, those are my two best authorities on those issues, and in Eves versus Harris, Matthews v. Eldridge is also cited, which brings me to my second point, that the acts that the Superior Court found to be a violation of Section 45, that the acts that the Superior Court found appellant to have committed do not satisfy the grounds for removal under Section 45 of the city charter, which I would like to talk about the four grounds that are required under Section 45 of the city charter, and then talk about the reasons why the Superior Court found that Mr. Northway should be removed from office. The grounds, there's four grounds listed, and it's our position that those are the only four grounds that can be violated to be removed under Section 45 of the charter. All four grounds basically require the equivalent of corruption. They require evil intent, flagrant acts, a continuous course of reprehensible conduct, not mere negligence. It must be gross negligence, and that the act be connected in some way to the office. Malpractice in office is Cargile versus State lends the definition for that, describing the evil intent. Chattooga County Board of Education versus Searles is a case on point for the willful neglect of duty. And for the remaining two grounds, I looked up Black's Law Dictionary definitions because I couldn't find a case in Georgia, at least on point, that would describe what was required of gross and willful abuse of powers. And then the remaining last ground, which is for any reason become unfit or incompetent to fill the office, which I think in interpreting the last ground, if the court doesn't agree with our arguments in our briefs regarding the vagueness of it, that it should be considered, and I'm not sure how to say the Latin phrases, but it's a jus dum generis. I believe I practiced that, and I think that's it. But that you would look at the general ground that follows the three specific grounds and give it the same meaning, apply it the same way as the first three specific grounds, which all require some kind of malicious intent or repeated reprehensible conduct. And the case that I'd cite for being on point for that specific issue is Georgia Board of Chiropractic Examiners versus Ball. I didn't bring that up in my briefs. It's 224 Georgia 85, 1968 Georgia Supreme Court case. Now, on to the reasons why the Superior Court removed Mr. Northway. I'm going to go through each reason why, and then I'm going to go back through and tell you why they don't meet the grounds for removal under Section 45 of the City Charter. The first ground is that Mr. Northway made statements while shopping at an antique store with his wife that undermined the authority of the City Council. The second ground is that he disclosed executive committee information in violation of the Open Meetings Act. Third is that he discussed flooding issues in a neighborhood where he lived, although his own property wasn't affected. And The fourth reason is that a single written warning to the city clerk, which was based on a misunderstanding, formed a basis for removal under the city charter. In that regard, a single written warning to the city clerk, in our opinion, does not meet the definition of one of the grounds for removal under Section 45 of the Charter. It was a single written warning, and as I've stated in the law and the circumstances of that written warning in my brief, that it was based on a misunderstanding of where the meeting minutes from the city council members' council meetings were being kept, and that the only person that didn't know that the meeting minutes were going to be moved was Mr. Northway himself, and that the clerk and the city manager anticipated that there would be a problem with this and audio recorded the mayor when he came to ask about where the meetings were, where the meeting minutes were. And now that's Exhibit 5 of plaintiffs is the actual written warning that he provided to the city clerk. And it's our opinion that that doesn't meet the definition of gross negligence. Or
where did this audio recording take place? It wasn't at City Hall. It was at
it was at City Hall.
At City Hall?
Oh, there were two audio recordings, Your Honor. There was the audio recording at City Hall where the city clerk made the audio recording of Mr. Northway trying to get the meeting minutes. And then there was audio recording at a local antique store where Mr. Northway made the statements that allegedly undermined the authority of the city council and city manager. That was made at an antique store. Mr. Northway had gotten off of work and gone with his wife to pick up a lamp. So you hear the owner of the shop and a citizen of a neighboring town were making an audio recording regarding historical sites in Effingham County. And while they were doing that, Mr. Northway and his wife entered the antique store and went about shopping, and they were exchanged some pleasantries with the shop owner and this lady. And then when they were checking out, they engaged in a conversation, which in our opinion had no connection at all to the office of mayor. And in that conversation, the Superior Court found that several of his comments, and those comments are all listed, and the appellees have not included any additional comments that they believe violated the city charter. But in my brief, I listed those comments, and that they found that they undermine the authority of city council and the city manager. Now, regarding the First Amendment challenge that we've raised, the as-applied challenge, I would just at this point out that there's no question in my mind, and I couldn't find any law where it would be legal for a city, if they were going to draft a law that said you couldn't undermine the authority of the city council or the city manager.
Well, what is the definition for what undermining means?
Sir, I didn't look at that. I could file a supplemental brief and try to help the court out. I had no idea, and I think that leads to the vagueness argument of just as it's been applied to Mr. Northway, that it's undermined the authority. I think as applied to him, it would seem to me that Congress, there would be no one left in Congress, because anybody that was in the minority in Congress that undermined the majority would have a removal petition filed against them, and they'd be taken out of office. To me, it's a clear First Amendment right and I mean, he was shopping with his wife. It was clearly a personal communication that he's been removed for in acts and furtherance of his free speech rights. In that same conversation that was audio recorded in the antique shop, he also allegedly disclosed executive committee information in violation of the Open Meetings Act, which is not a violation of the Open Meetings Act. There's no part of the Open Meetings Act that says comments that are made in an executive session cannot be discussed outside of an executive session. I do not claim that could never be a violation for talking about executive committee information outside, and I think those type of situations would be where you were taking the information that you learned in executive session and you were going outside of executive session, maybe to a business partner. You formed a dummy corporation. You're going to buy some kind of land that the city council or that the city was going to purchase and then sell it later for a marked up profit or something along those lines. May be, unethical, and but that's not what happened here. Mr. Northway was merely having a conversation. He made two statements that were unrelated in time, and the first time that I read the comments, I didn't know what they were even relating to. I had to ask my client.
What about the issue concerning his participating in a discussion or vote and a matter in which he had an interest?
Yes, Your Honor.
Something dealing with his subdivision?
Yes, Your Honor.
What happened there, please?
Okay. That is, he was discussing, he lives in a neighborhood that had flooding issues. Even though his property wasn't affected, some of his constituents also lived in the same neighborhood. He had previously been the president of the neighborhood association prior to becoming mayor, and the issues, his constituents would come to him and discuss the issues. Now, Mr. Northway, then, when the issues would be talked about at City Council, discussed the issues, and the court found that because he lived in the area, that he had a personal interest, a financial interest in having the flooding fixed, and that as a result he should have recused himself, even though there's no recusal law from discussing or participating in the discussion concerning those issues. What
was the evidence? I'm sorry. What was the evidence with regard to the financial interest? Was it only that he lived in the neighborhood?
Under cross-examination, yes, Your Honor. Under cross-examination, it was the questioning was directed along the lines of they had a real estate agent testified that in the economy, if people knew that there was flooding that had occurred in a neighborhood, that it might devalue the property. And Mr. Northway, having heard that testimony from the real estate agent, then said that that his property may be devalued because there was flooding in the neighborhood. Was the way I remember the testimony being. Which brings me to my best authority on that case, which is Story versus City of Macon. That's 205 Georgia 590 in 1940.